This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you very much, Madam Clerk. Good afternoon, folks. This is the November session of the Tennessee Court of Criminal Appeals here in the middle section in Nashville. My name's Robert Wiedemeyer. My colleagues with me on the panel today are Robert Holloway Jr. and Ross Dyer. Mr. Holloway, Judge Holloway is from Columbia, and Judge Dyer is from Memphis. So we have two middle section judges and one western section. We are obviously would prefer to get back into the courtroom, the real courtroom, but we're operating the best we can under the pandemic with these Zoom arguments. And it has worked pretty well, I think. We appreciate the clerk's office's efforts, and the AOC, Nick Morgan, has gotten us through quite a few of these. And so we're grateful to be able to do this, to hear the oral arguments that need to be heard on these appeals. We will have basically the same procedure that we normally have in court. Each side gets 20 minutes to argue. The appellant can reserve rebuttal time if they wish, any part of their 20 minutes. If you let me know on the front end, I think you, General Coleman, you were asking for how many? 3 minutes? Or
if I may reserve 2 minutes of rebuttal, Your Honor.
2 minutes, certainly. So you'll have 2 minutes reserved. I'll try to, if you get to 18 minutes, I'll tell you. It's not mandatory for you to use the entire 18 minutes. So we have, and along those lines, we have read the briefs. So we're prepared to that extent. We haven't been assigned the records, and but we're, if you want to tailor your arguments based on the fact that we are familiar with your briefs, that's fine to do. I think that's all the preliminary matters I have. Ms. Lindsay, if you would be kind enough to call the first case on the afternoon docket, please.
State of Tennessee versus Quinton, Deshawn, Mostella.
Thank you. So, General Coleman, this is a state appeal, is that right?
Yes, Your Honor.
All right, you ready to argue the state side?
I am, yes, Your Honor.
All right, go right ahead.
Thank you. Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. As Judge Wiedemeyer pointed out, this is a state appeal from the trial court's entry of an amended judgment, which changed the consecutive nature of this sentence to concurrent, and also included the incorporation of pretrial jail credits.
General Coleman,
yes,
General, before we get deep into your argument, let me go ahead and ask you the first question that's on my mind. The original judgment, from the record, how do we know when it was entered?
Yes, Your Honor, it was file stamped. And so once it's been file stamped, there's significant case law out there that establishes once it's file stamped by the court clerk, it has been entered into the record, or it has been filed.
Okay, but is the judge's signature on it?
Yes, Your Honor.
But we don't have a minute entry. Is that really the only thing we don't have?
That is correct, Your Honor. And Your Honors, I'm sure, are as aware as I am of the numerous records that are before this court on various cases where a specific minute entry by a specific court clerk isn't entered. And nevertheless, the judgments are filed and marked as filed when they're file stamped at that time. Okay. So the state's position that this judgment was entered on January of 2019. But to that end, I think there's a factual background to this that there are a bunch of dates that get out. And so I would like to sort of walk this court through chronologically sort of what happened in this case. And so starting all the way back in November of 2008, the defendant had made bond for some unrelated drug charges. And so while he was out on bond, so he's out on bond as of November of 2008, in May of 2009, the defendant becomes involved in the murder, which is the judgment that we have in this case. So that's while he's out on bond. In August of 2009, he is found guilty of those unrelated drug charges, and he receives an 11-year sentence. So while that's all going on, while he's incarcerated for his drug charges, in January of 2017, he's indicted for his involvement in the murder. about a year and a half later, in October of 2018, that's when he pleads guilty to facilitation of first-degree murder. And a few months later, in January of 2019, he receives a 22-year sentence. And it's important to note that the sentencing hearing is in the record. And at the sentencing hearing, all the parties agree, were very much in agreement, that the offense for this facilitation of murder, the sentence for this facilitation of murder conviction, was to be run consecutively to any other charges that he was currently serving. For instance, the drug charges. That's volume 2, pages 158 to 160, as well as, again, on 191. So it was abundantly clear at the sentencing hearing that this was to be a consecutive sentence. Now, moving on, about 600...
Was it agreed that it's a mandatory consecutive sentence, or did they just agree it was consecutive?
My understanding is that all parties were in agreement that this was mandatorily consecutive, specifically because it was committed while the defendant was on bond for those drug charges.
And the original judgment is marked consecutive.
Yes, Your Honor. And there's a box that has concurrent with and a box that has consecutive with. And in the box that says consecutive with, it says all currently serving sentences, or something along those lines. So the original judgment does indicate that this is supposed to be consecutive. So we've got that judgment, which is entered in January of 2019, and about 600 days later, so June of 2020, the defendant files a Rule 36 motion, specifically says, pursuant to Rule 36, I'm seeking relief, and the relief that the defendant was seeking was only pretrial jail credit. The defendant made no mention of the consecutive versus concurrent nature of his sentences. In October of 2020, the trial court then entered a modified judgment, which not only reflected the jail credits the defendant felt he was entitled to, but also sort of sua sponte modified the fact that this was now to be run concurrently with all of his currently serving sentences. And so the state's position is that the trial court did not have jurisdiction to do either of those things. And I'll address the concurrent sentences first. So the court did not have jurisdiction to modify the defendant's current sentence to be run concurrently with the drug charges. The judgment, again, had been entered in for over 600 days, in which case it was clearly fine. The amended judgment entered after the court had lost its jurisdiction then is therefore void. And there are very slight circumstances where the court can retain jurisdiction to modify a judgment. Under Rule 36, the court can modify a judgment at any time to correct a clerical error. That is simply not what happened here. Again, back at the sentencing hearing, it was abundantly clear that this was to be served consecutively. And to the extent that the parties might disagree on it now, the fact of the matter is that was not a clerical error. That was not I made a mistake in putting it in one box versus the other. Everyone was under the impression that this was to be served consecutively. So because it's not a clerical error, the court cannot modify the judgment under Rule 36, and the court retains no other jurisdiction to modify the judgment at all.
I assume he had already been transferred to TDOC. He wasn't in local custody, correct?
That is my understanding, yes, Your Honor. Again,
it doesn't make any difference, but there are some jurisdiction issues involving local custody. I don't know if it'd be applicable here.
I believe you're certainly correct, Your Honor. I don't think any of those would apply here. And so again, regarding the sort of sua sponte concurrent sentencing, the trial court simply did not have jurisdiction to modify that as part of the judgment.
Did the trial court give the reasons for doing it?
No, Your Honor. I went and actually double checked the record today, and there was not even specifically an order like granting relief. Instead, the trial court simply entered a modified judgment in response to the Rule 36 motion. So the court there's nothing in the record that would indicate why the trial court decided to do this, or its reasonings, or why it felt it was justified. We simply have the modified judgment now.
So there's no hearing either then?
Correct. The only thing in the record, the only hearing in the record is the sentencing hearing from January of 2019. So again, we really have no basis for why the court did what it did. But regardless of why the court did it, it did not have jurisdiction to do so. And so the first thing the state is asking is that you remand for the entry of the original judgment, which indicates that these are to be run consecutively. And then going to the pretrial jail credit, the trial court erred in granting that pretrial jail credit, specifically because the defendant was currently serving his sentence for the drug charges during those days. The defendant was requesting jail credit for the time he was incarcerated between his indictment and his guilty plea. But during that entire time period, he was serving his sentence for the drug charges. And the simple fact of the matter is you cannot double dip. He is not entitled to those credits as pretrial jail credits for this murder offense or this facilitation of murder offense.
That's provided they are consecutive sentences, right? Consecutive sentences. If they were concurrent, couldn't the defendant get those credits? Basically get them against both sentences. Not double, but one credit against all sentences.
So I think if it counts as, if it's to be counted as pretrial jail credit, even if they were eventually run concurrently, my understanding, and I have not thoroughly researched this issue, Your Honor, and I'd be happy to file a supplemental brief, but my understanding is that even in that situation, he would not be entitled to it. But if he were, that certainly still is not the case here. Again, it was very clear, it was abundantly clear for the proper statutory reasons that these were to be run consecutively. And so in that case, very clearly, he cannot get those pre-trial jail credits while he's serving them as post-conviction credits for a separate offense. And so,
well, I mean, this isn't any different than, let's just say he'd gone to trial on both of these cases and he'd been sitting in jail waiting for both of these. They're tried together. He's sitting in jail waiting. He gets convicted of 2 offenses and the trial judge runs them consecutively. He only gets the credit on, quote, the first sentence he's serving. He doesn't get, 120 days on sentence 1. And then when he finishes sentence 1, he starts sentence 2 with 120 days of jail credit, correct?
that's exactly correct, Your Honor. You should only get credit for the time you're in jail the one time.
Okay. So this wouldn't be any different than if he'd gone to trial at the same time.
Exactly, Your Honor. The only difference was these were tried at different periods, or these convictions were entered. But again, the defendant was already serving this time for his drug charges, and he's not entitled to get it in addition to it for his facilitation of murder conviction. If there are no further questions, then the state respectfully requests that this court reverse the modified judgment and remand for reinstatement of the original judgment. Thank you.
All right. Thank you, General Coleman. Counselor, pronounce your last name for me, please.
That's Badur, Judge.
Badur, thank you.
Judge Holloway found that funny.
Yeah, I find that funny. I went to law school with his father, and I know Colby Badur from Giles County too. So,
all right. Well, let me first compliment you on your patriotic background that you've got behind you there. It's always encouraging to see the stars and stripes boldly displayed like that. So appreciate that. Are you ready to argue?
Yes, sir. I will.
Go right ahead, Mr. Badur.
May it please the court. This is certainly a unique way for me to do this. I'm sure General Coleman has done this way before. But this is a first for me. I am Colby Badur. I had the pleasure of representing Mr. Mostella before the Murray County Circuit Court back in 2018. I maybe even started in 2017. I did not represent him post sentence at the motion, which gave rise to the amended judgment, which is now at issue, but found myself representing him here before this court. And to be perfectly candid with the court, I find myself in the unique position of really having to walk a tight line between balancing my obligations to zealously advocate for him and be perfectly candid with this court. This is a unique situation procedurally, in my view. Before the trial court, we had an open plea to facilitation first-degree murder. Judge Hargrove, as the general pointed out, entered a sentence. The original sentence was consecutive, and then following the sentencing, Mr. Mostella filed a pro se post-trial motion to have these amendments, or at least some of the amendments that were granted, made. Judge Hargrove granted those. I don't know whether there was a hearing. I know that was one of the questions you had to General Coleman. I don't know if it was a hearing or whether or not she just took it under advisement based on the written motion and issued the amended order. But here, Judge, I think the issue really boils down to whether trial court lost jurisdiction in the first place. As Judge Dyer asked, in my view, this is a matter of whether or not the judgment was entered upon the minutes. The law is clear in that regard that judgments are not effective until entered upon the minutes. That was this court in 1977. The finality of criminal judgments dates from the entry onto the minutes. That was this court in 1978. I recognize that in the late 70s, things were done much differently than they are now. There's actually minute books and all of those things as compared to everything being digitized and scanned, things of that sort. But the law remains unchanged, and that is the law. Entry of the minutes is the date that matters. Here, we can only assume that Judge Hargrove, or that or the original judgment was entered upon the minutes. I can only assume that happened somewhere near in time that Judge Hargrove signed the original judgment. But the record doesn't reflect that. And while typically I don't have the criminal defendant doesn't have the benefit of arguing that the record is incomplete and that should benefit them, here the record is incomplete in that respect. And frankly, as I see it, the burden is on the state to show this court, the court that's asking that the judgment be reviewed in front of, that the record was sufficient. The state simply didn't do that. And in my view, the court's precluded from hearing the issue at all because the record is unclear. I think that same line of thinking flows into the second issue about the sentence credits. I don't disagree with the procedural history. Mr. Mostella was on bond for another offense. There was discussion about the mandatory consecutive nature before the sentencing court at the sentencing hearing. My view on that is unchanged. The law is what the law is, and I don't pretend that it's not. However, the cases cited by the state simply don't support their position.
Let me ask you this. So
yes, sir.
Let's assume you're correct that the trial court had some jurisdiction here because we don't have a minute entry and the file stamp from the clerk's office isn't enough. So the court has jurisdiction. Where's the clerical error that the judge is correcting? Even if they have jurisdiction, what are they? I mean, as we were asking Mr. Coleman, if the two sentences are consecutive, let's just start with the jail credits. I mean, I guess it's a chicken or the egg kind of question here, but if the two sentences are consecutive, the law is very clear. You only get credit for one of them. You only get jail credit on one of those sentences. So you can't double dip on the jail credits. So there's no error there. And if the record's very clear that the trial court, that the defendant was on bond and therefore consecutive is mandatory, and they discussed it, and the original judgment has the consecutive box checked, what error is the judge correcting?
Judge, it's my understanding of the law that the trial court can enter an amended judgment to correct a clerical error after the judgment becomes final. It's the position of the appellee, Mr. Mostella, that the judgment never became final because it never was entered upon the minute books, and therefore doesn't have to be simply a clerical error for the trial court to make an amendment. Okay,
and I would agree with you that. But so then let me change my question a little bit. If you still can't even if the judgment's not final and it's mandatory consecutive, and it's, at least we hadn't seen the record, but at least from Mr. Coleman, and you at least allude to it, that it's pretty clear from the transcript of the sentencing hearing that they discussed this, and therefore consecutive is required. How does she impose, or how does the trial judge impose concurrent sentences?
Judge, I do understand your question. I have been put in a position of walking a tightrope, and while at sentencing, I agree. I really don't know how to answer that, to be honest with you, perfect judge. I don't know how to answer that.
You say it's the inherent power of a circuit judge.
There's hard road especially.
But you know, I mean, just add one thing to Judge Dyer. It's also an illegal sentence that she's now imposed because it's a mandatory consecutive sentence, which any party could correct at any time under 36.1. That's another issue, I think, about her doing it the way she did.
I mean, to me, and I get your point, Counselor, and I understand the line you're trying to walk here and the balance you're trying to make. But to me, no matter how you cut this, we really end up with consecutive sentences and 700 days applied to the first sentence, and that's it. I mean, if the trial judge lacked jurisdiction, that's the result. And if she didn't lack jurisdiction, it still wasn't final, as Judge Holloway just pointed out. Imposing concurrent sentences is illegal. The state's going to turn around and file a motion, and we're going to be right back to where we were in 2020 or 2019. No matter how you slice this. You don't have to answer that because I know you're walking. I understand.
I'm sorry, Judge.
If I understand correctly, Mr. Badur, you represented Mr. Mostella back when you entered the plea.
Yes, sir.
And that case was over. And without you knowing about it, he filed a pro se action, and the trial court entered up an order on his pro se action. And when the state appealed, they called you and appointed you. Is that right?
When the state appealed, I got a notice from the clerk's office that I was now representing this gentleman on appeal. And look, Mr. Mostella, as far as clients go, was maybe one of the best clients I've ever had. And frankly, he did a really good job with Judge Hargrove at the post-trial hearing, apparently. But here I am, and here we all are.
And I was all prepared to tell him what a great job you did at the trial level. Now found out it was Mr. Mostella.
Well, Judge, I'll take the credit nevertheless.
You have done an exceptional job walking a very thin line, and I appreciate it.
Judges, I tell you, this may have been the shortest appellate brief that I've ever written, but it was most certainly the most difficult.
All right. General Coleman, any rebuttal?
Yes, Your Honor. Just very briefly on this, when the judgments were entered, the defendant relies on a 1977 case. And at that time, he would have been correct that minutes were required. But a number of statutes were passed during that time. A number of rules were passed. And pretty explicitly, this court opined on this exact issue back in 2007. It's a published case. It's in our reply brief, State v. Stevens. And it says that a file stamp date, and I'm quoting here, file stamp date provides evidence of when the order of sentence was entered by the clerk. Thus, the effective date for entry of a judgment or order of sentence is the date of its filing with the court clerk after being signed by the judge. And that's what we have here in the record. We have a judgment that is signed by the judge that is file stamped by the court clerk in January of 2019. And so at that point, the judgment was filed and it became final 30 days later. If there are no further questions, again, we respectfully ask that this court reverse and remand for entry of the original judgment. Thank you.
All right. Seeing no further questions, we'll take this case under advisement and get an opinion out in a timely fashion. And Mr. Badur, I don't know if you meant this was your first Zoom docket or your first appearance before the court, but either way, we appreciate your accepting the appointment and hope you'll appear before us again in the future. And good briefs, good arguments, gentlemen. Thank you very much.
Thank you, judges.
All right. Madam Clerk, we'll adjourn then until the next case.
This Honorable Court of Appeals of the State of Tennessee is in recess until 2 p.m.